SV Raju, the additional Solicitor General of India, is now joining us on Times Now. Sir, good morning. Thank you for speaking to us. What do you make of what the Supreme Court has said in denying bail to Umar Khalid and Sharjeel Imam?
If I may say in 2 words, is the right decision. These 2 people don't deserve bail. They're anti-nationals. They want India to be cut into pieces. They want Assam to be cut off from India. They want to sever the chicken's neck and dismember India. Such type of people should not be granted bail. I'm not saying without any evidence. The evidence shows their involvement. The court has gone into the evidence. Court has put a lot of effort, gone into the depth of the matter. They've gone into the law, laid down very good law as far as how terrorists and anti-nationals and how the UAPA Act is to be construed. It's a very well written and a great judgment.
Mr. Raju, many people before the verdict today were, talking of liberty and how the Supreme Court must ensure that liberty is not at threat. Now that the Supreme Court has ruled and said that for next 1 year, Umar Khalid and Sharjeel Imam can't apply for bail, do you think this is a response to all those people?
See, I tell you one thing. What is the use of liberty if there is no country? The country, therefore, you have to balance between the rights of the nation, rights of the society, and rights of individual. According to me, the most important right is the right of the nation and the right of the society, and thereafter the liberty clicks in. You can't say in abstract, no, liberty is paramount. No, it's a balancing act. And persons who are terrorists, who are indulging in anti-national activities, terrorist activities, have to be treated differently. The law treats them differently. Section 43D5 treats them differently. There is a reason for it. Because if there are terrorists and if there are terrorist acts, you'll have liberty, but you'll have no nation. What is important to me? According to me, nation first is the most important thing.
Right. Nation first. But sir, every time, I'm sure you're aware of the commentary that goes around. Every time someone talks of nation first, patriotism, there is a section in our society. And, for lack of a better word, they are referred to as the lobby or the ecosystem. They say, look, do not hide behind patriotism. The rule of law must apply.
Yeah, nobody is saying that the rule of law is not applied. The judgment has applied the rule of law as it should be applied. The judgment has gone into facts. All these persons who comment, they don't know what are the facts of the case. They have not read the charge sheet. They have not read the statements of witnesses. They have not gone through the documentary evidence, and they just make a statement for the heck of it. Such people can't make a statement without going into the record of the case. If the record of the case substantiates that these persons don't deserve bail, that is it. They don't deserve bail.
Mr. Raju, for a considerable period of time, there has been a sustained commentary, and without taking names and going into motives, I want you to break it down for our viewers. There is a section that has, painted, so to say, these 2 individuals as martyrs. They would have us believe that here are 2 individuals who've been persecuted, maybe because of their religion.
That is totally wrong. They have not been persecuted because of their religion. They have been prosecuted because of the evidence that is there in the case against them. Because of the law as it stands today. The law as it stands today says that if you're a terrorist, you don't get bail unless you demonstrate prima facie that no offense under the UAPA chapter 4 and 6 is made out. We have demonstrated that they are not ordinary persons. They are the brains behind a so-called agitation, which was never an agitation. It was Chakka Jam, which was meant to strangulate the economic supply or the supply chain of essential articles to Delhi. They were the masterminds who wanted actually Assam to be separated from India. They wanted chicken neck area to be blocked so that Assam gets separated. How can you compare these persons with ordinary criminals, and how can you call them martyrs unless you have not read the documents? It is like an ostrich policy. You don't see what is around. You just go in and you don't see that nothing is there. So it's like an ostrich policy without going into the documents and the evidence and the law. So these people are also, I mean, saying something in sympathy without realizing the facts, without galvanizing the facts.
You're right. And these are not ordinary individuals that we're talking about, Mr. Raju. You know, for instance, you have someone who, like P. Chidambaram, a senior advocate himself. You know, some would say that he understands the law. He has said Sharjeel has been made a scapegoat. Then you have a senior leader of a political party, you know, like someone like Digvijay Singh, who said Sharjeel is innocent, he's being harassed. And also the foreign commentary around it. Just recently, the New York City Mayor Zohran Mamdani wrote a handwritten, you know, letter to Sharjeel and said, "We are all thinking of you."
See, the picture that must have been painted before these persons must be different than the actual scenario or the actual facts. It is only when you look at the charge sheet, which is 2,500 pages, and when you look at the law. Mr. Chidambaram may know the law, but I'm not sure as far as criminal law is concerned. The extent of criminal law and UAPA Act is concerned, I have my own doubts. I may be wrong. But the fact is, you don't only go by law, you go by facts. And if you look at the facts, in detail, no sane person can say that Sharjeel Imam or Umar Khalid requires to be granted bail. It could be a superficial view of yours without looking to the papers, and therefore they may, according to me, they might have faulted.
Mr. Raju, for the ordinary viewer, you know, could you please explain why Umar Khalid and Sharjeel Imam have been called as the alleged mastermind of the 2020 riots?
I'll tell you what our case is, Deepak. The case is that they wanted a regime change, like what happened subsequently in Bangladesh and Nepal. They wanted a regime change. They tried it at the time of Babri Masjid, but they could not garner sufficient strength. The number of persons that came were few. Then they thought that CAA is the opportunity that is so-called given to us, where we would be able to garner strength, we'll be able to gather crowds, and then implement what was their aim of regime change. So this is how the entire planning was done. The agitation or protest against CAA was only a facade. The real thing was regime change. And this simple protest was not the issue. They wanted chakka jam, they wanted violence. We have demonstrated from evidence that this was not an ordinary protest. This was a protest where violence was going to be caused, and they had planned for violence. They had made use of weapons. 53 persons were killed, 530 persons were injured. This is not a simple protest. And the entire aim was to create turmoil and create this pan-India so that the government is forced, some action is forced by the government, or there would be a regime change. That is our case. And if you want a simple protest, you don't say that cut off Assam from India. You don't say take away chicken neck so India will be helpless. You don't say Bharat ke tukde tukde karenge. These are these type of persons who the general public do not know the real intention and the real person who is having a mask in front of him. That is why the entire controversy has arisen.
Mr. Raju, as someone who's you know seen this case up close, what do you think about the narrative that Umar Khalid sought repeated adjournments on his bail hearing, sir? Because many people have weighed in on that. What is your view?
It is not only bail hearings. It is the discharge. He applied for discharge. The trial, you know, Deepak, doesn't proceed unless the charges are framed. Every attempt was made to delay the hearing on charges. They did not make arguments on charges on umpteen number of times. We have demonstrated that the delay, if any, is caused in the trial is only because of the accused. In fact, the Delhi High Court judgment supports our view, fortifies our view, and says, yes, these are the accused who are responsible for delay. If you're responsible for delay, you can't take it as an instrument for getting bail. You can't take shelter yourself behind delay which is caused by you, and we have demonstrated beyond doubt that delay was caused by the accused.
Mr. Raju, there's also this free speech argument, put forth by those who think that Umar Khalid and Sharjeel Imam may have a case. What would you tell them?
See, there is nothing like free speech in the abstract. Free speech can be curtailed under Article 19 of the Constitution by reasonable restrictions, which are in the interest of so many things, exceptions like sovereignty of India, etc. So as far as the concept of free speech is not that you can do anything and whatever you want. If that was so, there would be no case for defamation. But this is not that. Free speech doesn't mean that you create a speech and say we'll dismember in India and create separate Assam and have an agitation for that. That is not what free speech is for. So they have all misunderstood what is free speech and they have twisted what is free speech. That is what I feel. And this is for misguiding the general public at large. There's nothing like free speech in the abstract. There are restrictions. There are certain restrictions which even the concept of free speech accepts.
Even as we speak, sir, I am reading of social media, and this is a reaction from the CPIM. It says the Supreme Court's denial of bail to Umar Khalid and Sharjeel Imam, who've spent over 5 years in jail under the draconian UAPA, is against the principles of natural justice. Now, there are many people who've cited prolonged, pre-trial incarceration. They've said that this violates the most fundamental principle that bail is the rule, not jail.
No, in the UAPA cases, it's the other way about. That's what one judgment of the Supreme Court says. Because bail is not the rule. Jail is the rule in UAPA cases. That is why 43D5 is incorporated. It says if there's a prima facie case, you're not entitled to bail. So that general principle is at variance with what is the law as far as UAPA is concerned. One. Number two, all these persons, as I said, they have not understood the real basis of bail law. They have not understood the facts of the case. They are prone to making general statements. Just taking, he's put behind bars for 5 years, therefore grant bail. That's not the law. The law is, supposing there's a serial killer and he goes on committing rapes and murders. He's in jail for 5 years, release him so that he commits another offense. That's not the law. It's not mathematical that 2 + 2 is 4. No, you have to look at the facts of the case and then decide whether delay itself can be a ground for bail. It's not a straitjacket formula. Article 21 doesn't say grant bail to everyone, every person if he's in jail for 5 years. That's not the law. You have to look at the facts of the case and the law and then decide.
Now, Mr. Raju, on the UAPA itself, there are many who believe that UAPA is used to target dissenting voices and, that it reflects a disturbing pattern of repression and selective justice. Their words, not mine.
I tell you, it may be in a given case, but not in this case. In this case, we have strictly gone by evidence. Evidence clearly suggests that it is not a case of false implication. There's evidence in the matter. So courts have gone by evidence.
Mr. Raju, there are many who believe that this is a poor reflection, on the judiciary. Many have in the past gone on to say that, a section of the judiciary is compromised, etc., etc.
That is totally wrong. That is absolutely wrong, at least as far as this case is concerned. The case is based totally, because I have gone into the depth of the matter. I've seen the facts. This is an absolutely correct judgment as far as Sharjeel Imam and Umar Khalid are concerned. All allegations are made by vested persons who have probably an axe to grind, but they can't make such type of allegations against the court. I'm sorry.
Mr. Raju, before we let you go, I want to understand from you, what does this judgment mean to you? And what is the message through this judgment to people who say that, look, here are two individuals who are being targeted because they hold a certain point of view?
That's totally wrong. They are not being targeted because they hold a certain point of view. They've been targeted because the evidence reveals that they are terrorists, they are masterminds. This judgment also, in a way, is appreciative of the voluminous work and the tasks that the Delhi police have undertaken. Delhi police have done a great job in collecting evidence. It's not easy to collect evidence, especially when the accused are intellectuals and they try to cover their tracks. Despite that, the Delhi police has done a wonderful job. So I must congratulate the Delhi police. It'll give them support. It'll be like a shot in their arm that if you're doing your right duty, see, if an officer investigates and finds a crook who's an anti-national, anti-terrorist, entitled to dismember India, break off Assam from India, and then he finds that the court grants him bail at the drop of a hat, it will be so disheartening. People who are working for India, working as anti-nationalists, nationalists, working as terrorists will be demoralized. This judgment, in a way, will give a boost to the police activities who are involved in catching actual criminals, actual terrorists. That is one thing. Secondly, it recognizes the principle that mere delay is not a ground for bail in heinous acts, heinous crimes. You may try to cover your tracks by saying that, oh, I did nothing, but overt act is not, even preparation is sufficient, even conspiracy is sufficient to invoke the provisions of the UAPA Act. This is in fact a case when it's not a case of preparation, it's a case where 53 innocent persons were killed, 530 innocent persons were injured, and then you say, oh, I did nothing. You were the mastermind, you orchestrated everything, you will pull the strings, and now when it comes to bail, you sing a different song. This is totally unfair on the part of the accused and on the part of those persons who are trying to support them.
My final question to you, Mr. Raju, is this. Would the Delhi police challenge the bail granted to the others with conditions? Would you go up in appeal?
I have not seen the judgment, but you can't go into an appeal. Supreme Court is the final court. There's no question of any appeal. Maybe a review if there is something, error apparent on the face of the record, but I think it is a reasoned judgment.
Okay.
So in a bail, it will be difficult to challenge, even if the Delhi police want to challenge. But I'll have to look at the judgment. If there are something in the judgment which warrants a review, we'll definitely consider it.
Thank you, Mr. Raju, for speaking to Times Now viewers. You've heard from the man who knows a thing or two about this case, that delay in trial can never be a ground for bail, at least in heinous offences like the one Umar Khalid and Sharjeel Imam are accused of. We are taking a short break.
They can't be per se a ground for bail. That's what I say.
Right. Yes, sir. Thank you. We're taking a short break, viewers. Lots more lined up on the other side. Stay with us.